The Corporate Transparency Act is a new law that can wreak havoc on your life and business, but there are still so many business owners who don't know what this law is or that it even applies to them. But I don't want you to stay in the dark. Let's take some time and walk through the key elements of this new law so that you have a better understanding of what's required of you as a business owner, especially if you own trademarks. Hey friends, welcome back to my YouTube channel. I'm Faith Mitten, an attorney on a mission to simplify brand protection for entrepreneurs and business owners. On this channel, you will find tons of easy to understand, free, and practical insight about trademarks to help you get a better sense for how to protect yourself and to stay on the right side of the law. Now, I know you're probably wondering, what does the Corporate Transparency Act have to do with my trademarks? And that's exactly what we're going to explore today. But let's back up for a second and shed some light on what the Corporate Transparency Act is, why it was passed, and who it applies to. The Corporate Transparency Act, or CTA as I will refer to it from now on, is a major overhaul to our legal system involving business and business law. Prior to the passage of this law, there was no single central database of all the businesses that exist in the US. Now, don't get me wrong, each state maintains its own database of all the businesses that are set up in that state. But these databases do not link or communicate with each other in any way. So finding information about companies is really difficult. On top of that, because each state has different requirements about what you need to submit to the state in order to set up a business, even if you could go to the state government's database to find information about the business and where it was set up, you wouldn't necessarily always be able to find information about the people who owned the business, the people behind the business. And for this reason, it made it really easy for people to set up shell companies to do illegal activity in the United States, such as money laundering or terrorist financing or other criminal activity. But other countries do have these kinds of databases, and that's making the US look really bad on the world stage. So because of this international pressure to get it together, the US Congress passed the CTA in 2021 to require that businesses nationwide, regardless of the state requirements, now begin reporting certain information about their companies to the federal government or face really harsh consequences. So who does this law apply to? Well, if you're a small business owner thinking that you're going to get a pass on compliance because of your size, think again. There is no exception for small businesses. And in fact, most of the exceptions to the reporting requirements under this new law are really only for businesses or other organizations that are already disclosing highly detailed information to the government on an ongoing basis. So the CTA creates a requirement for reporting companies to report certain information to the Financial Crimes Enforcement Network, also known as FinCEN, which exists under the US Treasury Department. Reporting companies include corporations and LLCs and any other type of business entity that is created by the filing of a document with the state government. There are domestic reporting companies, meaning those which are created within the United States, as well as foreign reporting companies who were created under laws outside of the US. So what information needs to be reported? Well, there are two main things that have to be reported to FinCEN: entity information and beneficial owner information. Entity information includes the name of your business, the state where it was formed, its identification number, its address, and its trade names, if any. Now, you know this YouTube channel is all about trademarks, and I mentioned earlier that some trade names may be trademarks, but not all trade names are trademarks, and we'll come back to that towards the end of the video. But moving on to the second type of information you're required to report under the CTA, which is beneficial owner information. And the collection and maintenance of this data is the entire point of the CTA. A beneficial owner is an individual, a person who has direct control or ownership over a company on the one hand, or who indirectly exercises substantial influence over the company on the other hand. So this may include owners of the company, executives of the company, the board of directors of the company, as well as many other types of people. For the beneficial owners, you will need to report their names, their date of birth, their addresses, a picture of their government ID that has a photograph of them on it, as well as the identification number that appears on that ID. And in terms of when you need to make your filing to FinCEN, the deadline depends on when your business was created. If your company was formed before 2024, you have until January 1st, 2025 to make your first report with FinCEN. If your company was formed in 2024, you have 90 days from the formation of your company to make your report to FinCEN. If your company is formed after 2024, you must make your first report to FinCEN within 30 days of your company's formation. And if there are any changes to the information that you have previously reported to FinCEN, you have 30 days from that change to make an update report to FinCEN. Seems pretty simple and straightforward, right? Wrong. There are many ways that CTA compliance can be unexpectedly complex and create legal headaches for business owners. But because this channel is about trademarks, I'm going to talk about 3 not so obvious trademark scenarios that could trigger non-compliance with the CTA. First, changes to a trade name that is also a trademark will trigger a new reporting obligation under the CTA. This is where a lot of business owners can trip up. You might be familiar with filing new trademark applications with the USPTO for different rebrands, but the CTA adds a new layer of complexity for this kind of legal work. For example, let's say that you formed a business under the name Jane Smith Consulting LLC, and you also filed a doing business as certificate to be able to use Tech Plus Solutions as your trade name. A trade name is an alias for a business that allows it to use and operate under a different name than its legal name. And let's say in addition to filing your doing business as certificate, you also filed a trademark with the USPTO for Tech Plus Solutions. Now, if you decide to rebrand and change the name to Tech Prestige Innovations, that simple change requires you to now do at minimum these 3 things. Number 1, file a new trade name certificate with your state or local government. Number 2, file a new trademark application with the USPTO covering the brand change. And number 3, file a new report with FinCEN updating them of the switch to Tech Prestige Innovations. It's just one more box to tick off on your legal to-do list. Second scenario, trademark licensing agreements, while often overlooked in these CTA discussions, may create some important hidden reporting obligations under the CTA. Because under the CTA, anyone who exercises substantial control or influence over business decisions is considered a control person or a beneficial owner. And that level of influence and control is precisely the kind of relationship that trademark licensors have with their licensees. In a licensing arrangement, the licensor is the party who is giving permission to someone else to use their trademarks, and the licensee is the party that is receiving permission to use someone else's trademark. These license arrangements can be a really good way for the licensor to make passive income off of their trademark and to monetize their brands. But in license agreements, the licensor must retain a significant amount of control over how the licensee operates, including over how the trademark is used, what standards the licensee has to meet in the production of whatever products and services that are being used with the licensor's trademark, as well as many other different considerations. This level of control is necessary for the licensor to maintain their trademark rights in their trademark. And this level of control and influence could mean that the licensor needs to be reported as a beneficial owner or control person, despite the fact that they may not have any ownership stake in the licensee's business. For example, If you own a popular clothing line and you license your trademark to a retail partner to be able to sell that clothing line on your behalf, the retail partner may need to report you as an indirect beneficial owner or control person because of the license relationship. But there's no one-size-fits-all approach to licensing, and some licensors maintain much more control than others. So some licensing relationships may rise to the level of being reportable under the CTA and others might not. Third scenario, trademark owners who use holding companies need to be aware of the CTA's reporting obligations on them. Many trademark owners set up holding companies to protect and manage their IP assets if they have a large and very profitable IP portfolio. This is a very common strategy to separate the IP from the operating company and shield it from liability, as well as for tax and privacy reasons. However, the CTA complicates this setup just a bit. Holding companies are generally not exempt from the reporting requirements, so you need to disclose the beneficial owners of the holding company to FinCEN. And note that the goals of creating a holding company may be somewhat at odds with the goals for the CTA in the first place. If you set up a holding company to conceal the fact that you own certain IP, be mindful that the CTA's purpose is to peel back all the layers and break down all the entity structures to find the human beings behind a very complex corporate structure. So it's not enough to report just the information for your operating company or your lowest subsidiary. While holding companies can be a really smart way to manage your trademark assets, they also require careful attention regarding the new transparency requirements under the CTA. But who cares? If you don't make your initial filings and update filings when due, does it really matter? Yes, it absolutely does. Like I said at the very top of this video, not complying with the CTA carries some really harsh consequences, including fines of up to $500 per day that your required report was late, as well as criminal liability. If you're concerned about the information that you're reporting being accessible to everybody and anybody, just be mindful the CTA's purpose is not to make your information broadly accessible. This information is collected by FinCEN and is supposed to be maintained in a confidential database that only law enforcement has access to. But overall, CTA compliance is nothing to joke around with, and it is best to navigate this new law with the help of an attorney, because while this video summarized some key considerations, it is only a summary, and as with all summaries, I have left a lot unsaid. So be sure to contact your own attorney for legal advice about how to comply with the CTA in your specific circumstance. And that's a wrap. If you enjoyed this video, please give it a thumbs up and be sure to subscribe to the channel for more trademark content and to turn on notifications so you never miss when I post a new video. If you've got thoughts or questions to share, please drop them in the comments. I read and respond to each one personally, and I would love to hear from you. Thank you again for watching, and stay tuned for the next video.